Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Indianapolis on September 28th through the 29th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode I am pleased to be joined by James Copland. James is a senior fellow with and director of legal policy for the Manhattan Institute. In those roles, he develops and communicates ideas on how to improve America's civil and criminal justice systems. James holds a JD and MBA from Yale. Thanks for joining me today, James.
Thanks for having me.
Now, you have written extensively on non-prosecution agreements and deferred prosecution agreements, including a recent report titled The Shadow Regulatory State at the Crossroads. Federal deferred prosecution agreements face an uncertain future. What concerns you about the DOJ and occasionally SEC's frequent use of NPAs and DPAs to resolve allegations of corporate crime?
Well, I'll give you a few reasons. At first, I just think it's interesting to point out, or necessary to point out, what a DPA or an NPA is. A deferred prosecution agreement is really just a form of pretrial diversion, where the federal government's been increasingly using these to resolve criminal allegations against large companies, particularly publicly traded companies, though not necessarily. When the SEC is involved, it is publicly traded. And a non-prosecution agreement is more or less the same thing, except that the criminal charges haven't been filed yet. And essentially what we find happening here is that businesses are avoiding prosecution for alleged crimes by paying hefty fines and agreeing to change their business practices. And that gives government attorneys, therefore, have tools that they use to modify or control or oversee the corporate behavior of these entities, and they'd never be able to do that if they took the companies to court. There tends to be a lack of transparency and essentially no judicial oversight for these. So each of these sorts of things generate concerns for me. On the one hand, what this means is a lot of this, what I call the shadow regulatory state, is occurring without actual adjudication at all. It's very rare when you see a company pushing back against the government, and there are various reasons for that, including the principally collateral consequences that the company would face, both statutory and just out in the market for going to trial. And so what that means is the government can push theories of law beyond statutory safe harbors, and I think in the FCPA context they've done just that. They can run with companies with fairly attenuated chains of jurisdiction, and in the FCPA context, again, I mean, you see regularly the federal government of the United States going after foreign subsidiaries of foreign corporations using jurisdictional hooks, such as they sent an email that was routed through a U.S. email server, or they paid for something in a dollar-denominated transaction that ultimately had to be rerouted through a U.S. bank. So you have, both in terms of jurisdiction and in substance, no real adjudication here. And then when it comes to remedy, you have remedies that are not authorized by a statute. There's no congressional statute saying you can put a corporate monitor in the company to look over the shoulder of what's going on in the business. They report to the government, but they're paid for by the company. Things like this are not statutorily authorized, but the companies agree to it to get out of going to trial and trying to defend themselves in a criminal transaction, and a criminal prosecution, excuse me. So these things, I think, are quite troubling to me.
All valid concerns. Now, some people might respond to that by saying, well, gee, if business organizations, including large publicly held companies, disagree with the DOJ or SEC's interpretation of facts or their legal theories, there's always an option of putting the DOJ or SEC to their burden of proof. So one question I have is, do you think business organizations and their tendency to be excessively risk averse are partly to blame for the current state of affairs that you so accurately describe?
I would say yes and no, and let me explain what I mean by that. I mean, I do think there is an inherent tension between corporate management's interests and, in some cases, shareholders' interests here. And this is, I also work in the corporate governance arena. This is sort of the classic, what we call agency cost tension between management's and shareholders' interests. Management gets paid well and they want to keep their jobs. Shareholders, at least shareholders in publicly traded companies with diversified portfolios, would tend to prefer management to be less risk-averse than management is. And a lot of our corporate law doctrine is designed to get around that sort of agency cost tension for that reason. So sure, managements of companies are going to be more likely to want to deal here than to roll the dice and take a risk. But if you were a shareholder of the company, you might be much better off if in some of these cases the company fought back. And if it goes badly and it's a bet the company risk, then that's okay if you have a diversified portfolio of businesses, because it's going to, in the long run, be better for all businesses out there if you're actually litigating some of these cases. So I do think that there's that tension there, and it's, in fact, potentially exacerbated by the conflict potentially between corporate employees' interests and the corporation's interests, right? Corporate employees, the senior managers, don't want to go to jail themselves, and that's probably more so than keeping their jobs. One of the biggest deterrents to their trying to take on the Justice Department and fight back is, well, we could prosecute you as individuals too. And so because of that, there may be a great tendency to try to deal with the Justice Department if that means, and of course it's not necessarily insulating employees from prosecution. And based on Sally Yates' memo late in the Obama administration, there's a new prerogative, which may or may not carry through to this administration, being placed on the DOJ actually to prosecute individuals when they can. But clearly individuals are going to be thinking about their own freedom as well as their jobs in negotiating this.
Yeah, because...
There's a flip...
Yeah, go ahead.
Yeah, go ahead. Well, there's a flip side to this, and the flip side is the companies don't have as much leverage as you might think, in the sense that these can be bet the company types of situations where it's an enormous risk for the company. If you are a federal contractor and you're going to be debarred from federal contracting, or you're a financial institution and you are going to lose your licenses, if you are a healthcare company and you're going to be excluded from reimbursement from Medicare, these are bet the company types of situations where you almost have to play ball with the government.
Yeah, no doubt, as you note, different industries with different government contracting concerns have a lot of balls in the air, so to speak, when it comes to the decision of whether to put the government to its burden of proof. You know, I've remarked for quite a while now about the so-called Arthur Andersen effect, the notion that a company will crumble upon mere criminal indictment. From my perspective, that Arthur Andersen effect has been debunked as a myth. And last summer we saw both Federal Express and PG&E Energy, both publicly traded companies, took the DOJ to trial on criminal charges, and both of those companies are still around today and doing just fine. But point taken that in many cases the DOJ makes it so easy for companies to resolve alleged instances of corporate criminal liability that a business manager probably is making a rational business judgment decision that is in the best interest of shareholders, that is more time and cost efficient just by agreeing to resolve these things. But my concern, and I'd welcome your input on this as well, what in isolation may seem like a rational business decision, when you aggregate these separate rational business decisions, you have, at least in the FCPA context, excessive risk aversion is leading to an expansion of the statute, because a prosecutor is going to think, well, gee, that one company had competent counsel. If they agreed to this, this might be a viable theory. Let's move on to the next company. Let's move on to the next company. So how do we get this back on the rails, so to speak, given these dynamics you mentioned?
Well, I think it's an easier problem to diagnose than to fix. But what you're saying is absolutely true, and I wrote a lot last summer and have written about the FedEx case, because you saw precisely that with UPS and FedEx. I mean, as everyone knows, they're basically in the same business. They deliver packages, right? And in both cases, those two companies were accused by the government of distributing controlled substances and misbranding pharmaceuticals. What is that? That's people ordering over the internet, and Google was wrapped up in this as well, but ordering over the internet for pharmaceuticals, not heroin or cocaine, but OxyContin or other sorts of drugs, and getting those shipped, or also in some cases, Canadian supply of drugs or things like this. And so UPS and FedEx were just delivering the packages, and the government's theory was, well, you're going to deliver these packages, you need to be putting in rigorous compliance programs to try to look into what your customers are doing, so that you're not delivering packages from these internet drug distributorships or what have you. Now, UPS agreed to a non-prosecution agreement in the Northern District of California, and they had an extensive compliance program. They hired a new compliance officer. They developed a training program. They hired an independent auditor reporting to the government, etc., and paid $40 million. FedEx said, this is ridiculous, took it to court, and the government in their indictment sought more than $1.6 billion in fines, as well as the forfeiture of property in connection with the crime, which could have included planes and everything else, all while they were alleging a total amount in shipping payments that they'd identified over 10 years of $600,000, leading to a $1.6 billion fines being sought. So when you compare $40 million to $1.6 billion, you're absolutely seeing what's going on here, that, UPS, it's not crazy for them to agree to deal, given this exorbitant pressure. Now, FedEx, of course, won. The government backed off once they actually got in front of the judge, and the judge said, what in the world are you doing? But FedEx was essentially saying, we're not going to snoop on our customers. This wasn't particularly bad for FedEx's public image, and so they were willing to fight, and they had attorneys willing to do that. But it is a hard thing to fix. I mean, one of the things I think we need to rethink are the collateral consequences themselves. And this is something we've talked about a fair amount. But if you're going to just say any criminal conviction, or in some cases indictment, is going to mean you can't get reimbursed by the government or lose your licenses from the government, you create bet the company decisions, and the companies just can't fight back. So I think also you need to create real compliance defenses in here. The DOJ, I think, does try to take notice of compliance programs in theory, but I think Congress could step in here and do that. The other thing Congress could really do to narrow the scope here is specify very specifically in statute what a DPA DPA or NPA might entail, similar to what a plea agreement might entail, if the company is going to be doing something that's not authorized as a sanction under statute, right? Because none of the statutes say hire a corporate monitor. That's not the penalty under the statute. So Congress, while it's not going to be able to intrude on decisions whether or not to prosecute, which is a prosecutorial discretion case, and both the other two branches of government are somewhat limited there, and when it comes to remedy, they can certainly do that, and they can open up the process somewhat here. But it's a tricky situation. It's sort of like class actions, right? In any individual case, the company has an incentive to bargain with the plaintiff's attorney on a class action, even if it's a bogus one, because it's going to cost them too much to actually litigate the case. The problem there is it attracts a lot more plaintiff's lawsuits and class actions, and there at least you have a theoretical remedy if you've got an objector who can object to the class agreement. You don't even have that here. It's not clear who's going to object to these agreements when they're cut.
Yeah, as you note in your report, the single greatest use of NPAs and DPAs in any given year are often to resolve alleged FCPA violations. So what do you make of the following statistics? Since 2008, when DPAs and NPAs really became the dominant way for the DOJ to resolve corporate FCPA enforcement actions, less than 5% of enforcement actions against business organizations that were resolved with an NPA or a DPA have resulted in related criminal charges of company employees. You also just mentioned the Yates memo that was released in September of 2015. Well, since the Yates memo was released, and that was really nothing new, but more of a DOJ recommitment to individual prosecutions, there's been 19 corporate FCPA enforcement actions, and not a one, zero, zilch, nada of those enforcement actions has resulted in criminal charges against company employees. So what do you make of this massive, and it really is massive from a statistical standpoint, gap between churning out corporate enforcement actions but not holding any individuals accountable, recognizing that, of course, corporations can only act through real human beings?
Right. I mean, I think it's the most remarkable piece of this, and the piece that really sort of sheds light on it. I mean, folks who are critics from the left will say, oh, they're letting guilty people skate. People that are ripping people off are skating, and the companies are just buying off their freedom. And listen, in theory, there could be cases of that for the very agency cost reasons I was talking about. But the flip side of that is, in many cases, there aren't prosecutions here because it's very hard to build a case. And that's what's particularly troubling. Now, in the FCPA context in particular, sometimes there's not going to be an individual prosecution because the individuals aren't American. They don't have the jurisdictional problem becomes an issue for the individual, because if you've got individuals in Russia or the Ukraine or somewhere who are involved in these alleged schemes, you're not going to necessarily be able to prosecute those in the United States. But we have seen situations, say in the healthcare context, where there's a lot of off-label drug promotion types of non-prosecutions that agree in what they call a CIA in that context, a customer integrity agreement, but a parallel to the DPAs and NPAs. And the government's just had a very hard time making these cases. So they've had multi-billion-dollar settlements with pharmaceutical manufacturers, and when they try to actually prosecute the individuals, the general counsels, and other people involved, they fall flat on their face. And I think the Justice Department is very averse to doing that because once that happens, it raises a red flag up, and people like me are going to say, wait a minute, you pulled billions of dollars out of this company, and you're losing your cases when you go after the individuals who actually did the conduct that you're talking about. So I think they're worried about doing that, and they're worried about doing that for good reason.
Yeah, and I had the good fortune to testify at the Senate's FCPA hearing in 2010. That seems like yesterday, but it was almost 7 years ago. And, I pointed out the same dynamic. On one level, you could ask the question, well, gee, why was nobody charged? But I think the more accurate way to look at this massive gap is to sort of flip the issue and ask, are corporate FCPA enforcement actions that are resolved via an NPA, a DPA, or even now with this new resolution vehicle, a so-called declination with disgorgement, are these even viable, credible, provable FCPA offenses? And I think in many cases, the answer is no, but represent risk-adverse business decisions that companies agree to. And I think these statistics are further to that point. Now, as a senator, during confirmation hearings for the Deputy Attorney General, this was several years ago, but as a senator, Jeff Sessions stated, quote, "Normally I was taught that if a company violated a law, you charge them. And if they didn't violate the law, you don't charge them." Now that Jeff Sessions is Attorney General, shouldn't he just abolish the DOJ's use of NPAs and DPAs, particularly since you alluded to there's really no explicit statutory basis for allowing the DOJ to use these vehicles anyway?
Well, I think that kind of depends, right? I mean, I would certainly abolish a large chunk of the practice. In other words, I don't think it's unreasonable to say a company can enter into a plea or cooperation agreement of a sort, just like an individual can when facing criminal charges. But and cooperation agreements can be a little different, but you don't see individuals saying, "Oh, well, if you don't charge me for a crime, I'm not going to only pay some money, but you can put someone up in the guest bedroom of my house to look over my shoulder all the time," right? I mean, it is a bizarre level of remedy that's done here. So I really hope, based on that statement, that there is a very careful look taken here. And I have a lot of confidence in Rachel Brand, whom I know, who is the number 3 person now in the Justice Department, who understands these sorts of issues. I mean, it's complicated. Companies, if the end result of an abolishment were that there are a lot of corporate prosecutions on some of these same theories, I'm not confident that would necessarily be a good thing, because it would worry me a lot. I mean, since 2010, 16 out of the Fortune 100 companies have been operating under, at least for a portion of that period, under a DPA or NPA agreement. So if you had 1 in every 6 large American businesses being taken to trial, because the criminal code, I mean, stepping back from this, the criminal code, including the regulatory code, is just so vast. There's no way you're going to have a large business enterprise that's not violating some part of the federal criminal code. There's just no way, because it's such a vast code, no matter how good your compliance program is. So if the end result is that we're prosecuting all the businesses, I'm not sure that would be constructive. Ideally, what the DOJ would do is much more targeted sorts of looks at this. And what the FCPA is designed to do, and it's a salutary purpose, is to prevent large-scale bribery where businesses are getting money, getting contracts from foreign governments by bribing their officials, and this is something that has gone on, does go on, and is worth having a backstop against. But that's something quite different than many of these cases you actually look at that wind up with these NPAs and DPAs. So should they be abolished in their entirety? I think that kind of depends, but I would love to see leadership from the Justice Department clarifying this and going to Congress and saying, here's what we want to do to set up a real process with firewalls. Because, again, I always worry about the fact, this administration, Jeff Sessions is Attorney General for now. He's not always going to be. And if we don't do anything legislatively, there's nothing to stop the next administration from reversing course again. And the same is true with the settlement funds issue that they have already moved on. I mean, let me give a lot of credit. Last month, the Justice Department came out and said we're no longer going to be giving settlement funds to third parties, be they in criminal or civil situations. The Obama Justice Department allocated $46 billion outside the congressional appropriations process through settlement funds with businesses and other entities that were being targeted, going to third-party groups that the administration thought deserved the money in some way, as opposed to just reverting these funds to the general treasury. That's not going to happen anymore. But in that announcement, there was language suggesting that the DPAs, NPAs, among other processes, were valid tools, which does throw into question the total commitments to rethinking this broader process, and I hope that they will rethink it.
Well, so I've long argued that in the FCPA context, NPAs and DPAs should be abolished. But let me just say, I've also coupled that with the policy assertion that the abolishing of NPAs and DPAs needs to be tied to a compliance defense. And I think that would alleviate some of the concerns there. You know, you mentioned another major problem, and that is we almost have law by people, not law by statute. And that happens in the FCPA context because a lot of times over the last, 5 to 7 years, there's been, various congressional hearings about the FCPA, various discussions of amendments, various policy pronouncements by the DOJ and the SEC. And their response always seems to be, we don't need a statutory amendment. Let us just change our policy. Let us just issue guidance. Well, the fact of the matter is the people who wrote the FCPA guidance in 2012 are no longer at the DOJ or SEC. So you have this problem that you get these policy documents from real people who occupy that seat for maybe a year or two, and then they leave. There's really no consistency or transparency involving what's happening at the present time. The final question I'd like to ask is the FCPA turns 40 later this year. From your perspective, has the FCPA been successful in accomplishing its objective? And query what successful even means. And let me just, set this up by saying, is the FCPA successful if you see more prosecutions, not less prosecutions over time? Because you would think that if a law is successful, you would see the opposite. But in the FCPA context, there was more enforcement of the FCPA in its third decade than its second decade. There was more enforcement in its second decade compared to its first decade. Is that success?
I don't think that's success. I would say, though, that some of that's going to be based on more resources being placed on enforcement and more tools to track down things that are going on via email, electronic tracing, and things like this. And frankly, more robust compliance programs in the companies themselves, because a lot of these are self-reported. So the companies see something, they say, oh, wow, we've got to self-report. And in a lot of these cases, the company's uncovering these. And sometimes I'm shocked when I read the fact patterns how they could ever uncover it. They read like a James Bond novel. They've got a compliance program in place at the company, and you've got an individual who is driving out into an open field with another person, exchanging bags of cash, communicating only by text message on burner phones. How in the world the company's actually discovering that is pretty amazing. So the fact that there are more enforcement actions isn't proof that it's working. It's also not proof, I don't think, that it's not working, though. At a meta level, is there more corruption today or less corruption today than there was in the 1970s when it comes to all these countries in the world? There's probably a bit less, but it certainly hasn't been rooted out. And so I think the real question here is, what do we want to do? And we're never going to end this entirely. So sort of like the drug war, right? I mean, is there more or less drug use? I mean, there's probably less drug use. And then the question becomes, though, at what cost? What's the collateral cost of that? And that's what particularly worries me with some of these sorts of cases. Because if the FCA becomes a tool that the U.S. government uses against its own companies, against foreign companies, against subsidiaries without real ties to the U.S., you're creating enormous leverage for individuals that, as I say, they tend to be well-meaning individuals, and they're smart, but they're English majors with law degrees making decisions on whether American banks can go into African nations or what type of interest rate is going to be the bedrock floor interest rate that sets all contracts in financial markets in the world. I mean, these are huge decisions that are being affected dramatically by the decision of prosecutors, often not that long out of law school, with no business training whatsoever and no economics background. That's deeply concerning to me, and that's why I think it's really important to rein this stuff in.
Yeah, you're absolutely right. The notion that all FCPA enforcement, regardless of theory, regardless of resolution vehicle, is a net positive. I have some issues with that as well. Now, you mentioned, what is corruption? The interpretation and what the government views as bribery and corruption, it's a moving goalpost. It's moving. We've seen FCPA enforcement actions concerning internships and job opportunities. We've seen FCPA enforcement actions with allegations about golfing in the morning and beer drinking in the evening. So a lot of this is a definitional issue, and that definition seems to always be a moving target in some respects. Well, thanks for joining me today, James. Today's guest has been James Copland. He's a senior fellow and director of legal policy at the Manhattan Institute, and he has written some very good material concerning the use of DPAs and NPAs and related policy considerations there too. Thanks for joining me today, James.